elite institutions like Harvard, like Columbia, where I teach, those are important institutions, but that's only the tip of the iceberg of what the ultimate goal is, which is to not just get rid of race-conscious affirmative action, but also anything that makes us care or try to solve problems of racial inequality. And I think that that's a more alarming turn and will have serious impacts on people's access to employment and health. My name is Olatunde Johnson, and I'm a professor of law at Columbia Law School. Well, to me, the term affirmative action is quite imprecise. In common parlance, people often use it negatively. They might say, for instance, in polling, we see that people say that they're supportive of diversity, even though that's beginning to erode. People are making that seem like a negative, but people will talk positively about diversity, but sometimes they'll say, oh, affirmative action, that's a bad thing. And I think they see it, when people do think it's a bad thing, as allowing people who lack qualifications to advance in a position. So it has that negative tenor. The term is so capacious that without more refining, I think it really lacks meaning. I talk about race-conscious affirmative action to describe very specific efforts to either advance diversity or correct for contemporary unfairness, or to provide opportunity to groups that are historically underrepresented. To me, that's a more positive connotation of it. I think the idea that unqualified people are the ones who benefit from it is suspect, to say the least. There are many qualified people who could be in higher education institutions and in jobs. And in fact, despite qualifications, a lot of historically underrepresented minorities have not had opportunities. And so affirmative action is to make a stop and think and broaden the pool. And to make sure that our processes are fair and open in a way that provides opportunity to groups that have been historically not included. I would be remiss, especially in thinking about this in broader context, to say that a lot of social scientists note that if you really want to think about affirmative action, you have to think about it well beyond race. First of all, women are the biggest beneficiaries, white women, of affirmative action in this country. This is what the social science has found. We focus on race, but white women are the biggest beneficiaries because they're well situated to benefit. But also, we can describe a lot of government programs as a kind of affirmative action. Veterans Affairs programs that provide funding or special loans or special admissions programs for veterans. Those can all be described as affirmative action. Tax benefits that I get for purchasing a home and that were a big transfer of wealth in the 1950s, but that excluded African Americans. There's a really wonderful book written called When Affirmative Action Was White that describes the effect of all of those New Deal programs, as well as school funding and tax programs in creating a white middle class. So I think if you just think of affirmative action as this little program on the side that benefits African Americans who are undeserving, then it has a very negative tenor. But when we think about how do we marshal social policy, economic policy in ways that ensures that a broad base of people have benefits, then maybe we're able to think about it in a little bit more generous way, and I think more accurately. The term really came into use, or at least popular use, in the 60s. In 1961, President Kennedy issued an executive order ordering affirmative action for federal contractors to remedy past discrimination and ongoing discrimination against African Americans, and it was broader than that. It was eventually extended on the basis of religion, ethnicity, and to women. But it really started with this idea of fairness and of remedy, of recognizing that African Americans in particular had long been excluded from opportunities for jobs and in federal contracts. So it starts with a series of executive orders from the federal government, expanded under Lyndon B. Johnson and under Nixon. And eventually the concept makes its way beyond employment. And commonly today we think a lot about affirmative action in the context of higher education. So in response to student activism in the 60s, a lot of public universities and private universities started to think about ways in which they could provide opportunities to historically underrepresented minorities, as people would refer to people of color at the time. The University of California system, in particular Davis Medical School, had a program that set aside a few seats for its medical school for African Americans and Latinos. And that was challenged by a white man who said he wasn't getting in because of race and that this violated the Equal Protection Clause. There's a lot more to say about the Bakke case, but there's some things that are really important that really set up the legal battles over affirmative action that then continue for the next 40 years, really. So one is that the Supreme Court said that the specific program of setting aside seats, what people sometimes call quotas, that was unconstitutional, that it violated the Equal Protection Clause. And the court also said that, at least on the facts of the case in front of it, you couldn't use race to remedy general societal discrimination against African Americans. That's what the court said, and how they framed the term. But the court said that you could consider race as a plus factor, as one among many factors in furtherance of diversity. And it described diversity broadly, intellectual diversity, geographic diversity, and it considered race and ethnicity as one of those. So that's what really sets up the rationale for how higher education institutions pursued race-conscious affirmative action. Another big case was the Grutter v. Bollinger case, and that case reaffirmed the interest in diversity. This was a challenge to the affirmative action programs at issue at the University of Michigan. And you have this opinion by Justice O'Connor that talks about the importance of diversity, not just for classroom interactions, although she said that's very important, enhancing knowledge in the classroom, but also for building a cadre of leaders who could really lead a democracy that itself was meant to be diverse and also lead the private sector. So that didn't settle the issue. A group of people who are activists, who are concerned about the use of race as a factor, they had their sights on challenging that decision. So this resulted in the latest lawsuit, which is a challenge to the holistic race-conscious programs at the University of North Carolina and Harvard. And the way they differed from the Grutter case is that the allegation in those cases is that the way in which the university designed its admissions programs discriminated against Asian American students. And the plaintiffs were represented by a lawyer named Ed Blum, who had brought prior cases challenging race-conscious affirmative action. He also was the one who brought the Shelby County case, which resulted in the court rendering ineffectual a key piece of the Voting Rights Act. So this use, what he calls, of racial preferences, is really a big concern to him. So he went out and he says this is quoted, that he was looking for an Asian American plaintiff in order to have a new angle of challenging these cases. So the plaintiffs lost at the district court level, but they won in substantial way at the Supreme Court. And the Supreme Court in SFFA said that race could not be considered as a factor to advance diversity in higher education. It said that was just too diffuse and judicially unadministrable an interest. And that it promoted stereotypes, it risked racial balancing for its own sake. The court wasn't persuaded that it was something that universities should use, even though it said it's an important interest in the world, but you can't consider race specifically in order to achieve that interest. It risks harm and stereotyping of all sorts of groups, including Asian Americans. So that's where we are right now with the legal landscape. One of the things that's striking to me about it is how widely it's being invoked. So it applies, the decision by its terms only applies to higher education affirmative action, and actually leaves an opening. It says it doesn't ban all uses of race. In fact, Chief Justice Roberts, who writes the opinion, says in the opinion that universities can allow students to talk about their individual experience of surmounting racial discrimination. And so some universities have used that as an opening to have some sort of statement where students can talk or applicants can talk about their barriers. So I want to emphasize that opening is there. At the same time, a lot of universities have changed their admissions practices as a result of the decision, and we're really going to see the effect of that. We're going to, there's some schools in which the number of African Americans and Latinx students has gone really far down because of the SFFA decision. It's also having impact in the employment sector. Even though the decision doesn't apply to employment, it's being used in litigation to get rid of race-specific fellowships, but also diversity, equity, and inclusion programs. And then this may seem so far afield, but most recently it's being used in the environmental justice context to say that we don't have to remedy environmental harms that are affecting an African American community because that would require us to consider race, and we have to be colorblind. And this is in a case involving what is known as Cancer Alley, an area that has incredibly high cancer rates, the highest in the nation, asthma rates, where people suffer all sorts of heart ailments. It's the area in Louisiana between Baton Rouge and New Orleans. And I often use that case to talk about the impact of this. Elite institutions like Harvard, like Columbia, where I teach, those are important institutions, but that's only the tip of the iceberg of what the ultimate goal is, which is to not just get rid of race-conscious affirmative action, but also anything that makes us care or try to solve problems of racial inequality. And I think that's a more alarming turn and will have serious impacts on people's access to employment and health. It's important to remember that all of these cases, these affirmative action cases, they're brought as challenges under the Equal Protection Clause. And for many of us who know the history of the Equal Protection Clause of the 14th Amendment, it's an irony of sorts. The amendment was the centerpiece for abolitionists, people who they called radical abolitionists, including formerly enslaved people who wanted to instantiate full citizenship for African Americans. And so a key notion underlying equal protection is bringing African Americans, formerly enslaved people, to full citizenship. But now we actually see it being used mostly, and I think I would almost say primarily, but in a lot of different cases, to limit opportunities and remedies that are being provided that are race aware and that are race conscious. And so what I would say what enables that in the Equal Protection Clause, and what I might say to someone who uses the Equal Protection Clause in this way, is that you're forgetting its origins, which are about dealing with equal citizenship and subordination, and you're focusing on one aspect of it. It's often called the colorblind notion, the notion that equal protection is to advance a colorblind view. And the critique of that many of us in the literature have is that focuses on race as a classification, and that the goal is to get rid of the classifications rather than the goal being to get at substantive equality. So I'd want them to focus not just on the uses of race in law, but the purpose behind the use of race, and if it's to advance equality, to understand that. There's an interesting kind of tension at the heart of the Equal Protection Clause, which is that it has this very specific purpose. It came out of this abolitionist spirit, but it's written in universal terms. We all can benefit from equal protection, whether our ancestors were enslaved or not. I think that's a good feature of equal protection. I really do. I think fairness should be there for all citizens. At the same time, there has to be a recognition of the ways in which race has structured and limited opportunity, particularly for formerly enslaved people, not only for those categories, but there's a historical line there that the court often ignores. It's a very kind of ahistorical, decontextualized view of equal protection that is advanced in a lot of the recent jurisprudence.